Hi there, you're watching BloombergQuint, and this is the fine print. Now, most of you would know that on Friday last week, the Competition Commission of India passed an order against US e-commerce giant Amazon. The regulator has suspended the approval it granted back in 2019 to Amazon's investment in future coupons. Now, besides the penalty imposition, the CCI has broadly made three conclusions in its order. That in 2019, Amazon had misled the competition regulator to believe that the combination and its purpose were business of future coupons, that there was deliberate design on part of Amazon to suppress the actual scope and purpose of the combination, and that Amazon failed to notify future retail shareholders agreement as an interconnected part of the combination. Now, to just quickly recap, Amazon had invested roughly 1,400 crores, which gave it 49% stake in future coupons. The agreements gave Amazon certain rights vis-a-vis future retail. At that time, certain intra-promoter group transactions had preceded Amazon's investment, including acquisition of 7.30% stake by future coupons in future retail. Now, to understand what to make of this CCI curveball and its implications for Amazon and future group Reliance deal, I'm joined by Karan Chindyok and Sitesh Mukherjee. Karan, Sitesh, welcome to the fine print. Karan, we spoke on this very issue about, I think, 2 weeks ago, and you had mentioned that CCI has made the competition assessment it is supposed to in a deal of this nature, and that the regulator will have its task cut out if it wants to come to an adverse finding in its, compared to what it did in 2019. Has the CCI been able to do that in this order?
Well, personally, when we spoke at that time, we didn't have the benefit of this order, and we didn't have the benefit of the materials that the CCI were considering at that point. But what has since transpired is the CCI's view is that had everything been disclosed to me in the manner, my line of inquiry would have been different. And therefore, now it has given this direction that you come into a long form filing and you come to me and I will keep everything in abeyance. Now, this is where I think the order is that curveball you mentioned, because from a pure legal perspective, the CCI, the Competition Act says you take the CCI to take a view whether or not a combination is going to cause an appreciable adverse effect in competition or not. Now, the law doesn't say that you have to do it in Form 1 or Form 2. In fact, the regulations, and the CCI notes this in its own order the order of Friday, that this decision, whether it's a Form 1 or Form 2, it's a long form or short form, is voluntary on the parties. And in the past, in the last decade or so of combination enforcement, merger control in India, there have been combinations which would probably trigger a Form 2, but the CCI has accepted a Form 1 and approved them. And in this case, even assuming that there was a Form 1 filed, the CCI has done that competition assessment. So from an approval perspective, as to its impact on competition, that has already been done in its previous 2019 order. So, which is
that's the point that you made even in the last conversation, that irrespective of, let's say, the procedural aspects of notifying, etc., all the disclosures that were supposed to make in terms of transaction documents that have been made, and CCI has accepted this in its Friday order also. And the mandate of the regulator, that is to do the competition assessment of the overlapping relevant market, vertical and horizontal sort of overlaps, that had been done in 2019. So we don't know why the CCI is coming to this conclusion. Sitesh, can you make sense of it?
Well, for me, this matter raises a very seminal question about the CCI's regulatory authority and the power, because you see, the CCI, what we need to keep in mind, is not a licensing authority. So it doesn't license a transaction. It doesn't create a right. It just examines whether a particular right has the potential to cause adverse economic effect on competition in India. Now, and this power, the CCI has both ex ante and ex post. So, if a notification is made, CCI examines it and sees whether that potential exists. And if a notification is not made, or even after the combination goes through, ex post, CCI has the same power to regulate the combination if it finds that it is having a potential adverse effect on competition, or may yet have that. So therefore, to my mind, the CCI, unlike a licensing regulator, is a more active market regulator. So its oversight of the market is continuous and dynamic. Things change. I mean, who's to say that if the promoters were not selling FRL shares, this situation would not have arisen, and CCI would not have, questioned the filing that was done. So, suspending the approval that was given, to my mind, is a minefield which is getting created, because then it becomes a hotbed for business rivalry to play out in CCI, and for parties who have, where the transaction is hard to try and unwind it using the CCI. So I do think that, while the question of whether there was a misrepresentation or not is a more granular factual assessment, and it may not be fair for us to go beyond a point that to say that CCI was wrong or right. Maybe there should have been more disclosure. But at the same time, I don't think the framework of the Act within the framework of the Act, CCI should be taking such a step as to suspend the approval which it has already given, even if it was on the basis of certain information it did not receive. That apart, the fact is that this transaction was disclosed, and there were some negative rights attached to the transaction which were disclosed. Now, CCI has to actually, it's not like NCLT, it's not a judicial body that you bring all the facts and I'll give a decision. Having noticed this, and it was brought to their notice, they ought to have then examined the potential that it could have on the ability of Amazon to control the affairs of FRL. And that was a potential that CCI did not think necessary to examine. They would have asked further questions. They have the power to ask the DG to do an investigation. So it is also not a regulator where it must expect all the documents and the information to be placed before it in one go. And then, if something is wrong, then, they can unwind their decision. It's a dynamic market situation where it has to react to the business landscape changing continuously. People may have something in mind. If I acquire a financial investment in a company, I may in due course think that, I may have the ability to, if the promoter is willing to go out, take over the majority stake. But that's a remote business interest that I may have. But it's not the same as having created a right that I have a right to direct the affairs of the company. So I think this situation that CCI has created by suspending the approval it had given is fraught with some difficulties the way it has been done.
Sure. Well put, Sitesh, because look, I don't hold a brief for CCI, and I believe neither do you. What we are trying to do in this conversation is to understand the regulator's approach. And like Sitesh mentioned, this approach that could potentially open the doors to sort of business rivalries to play out and become precedent to unwind transactions in this fashion. And hence, I have a slightly more technical question for you, Karan. CCI says in its Friday order that Amazon failed to identify and notify future retail shareholder agreement as an interconnected part of the combination. Now, this interconnected has history, as you would also sort of explain to our viewers in just a bit. But the 2019 order says that the proposed combination also consists of certain other constituent steps involving intra-promoter group transactions between future coupons, future corporate resources, and future retail. I just want to understand what is the difference in something being interconnected versus something being a constituent step. Are they not one and the same thing? And is it not just a procedural violation, or is there a substantive violation that you sort of see here?
So, Prasvini, I think the answer would be let's first look at a hypothetical, and I'll come to your answers to the questions that you posed. If suppose the transaction was not notified at all, none of it, neither the SHA, the FRL SHA, or any part of the acquisition was not notified, the CCI could have today come forward and said, you failed to notify this transaction, and therefore you are under Section 43A. Now pay up the penalties that I impose on you. But that section does not take away that in 2021, there is Section 20 of the Competition Act, which has a limiting provision, which says that you cannot look into combinations after a year of their closing. So the transaction today having closed completely, and I assume a year has passed, more than a year has passed since then, therefore the power of the CCI to actually keep it in suspension is suspect. So therefore, it is at best a procedural violation that it was not notified. Whether it was notified incompletely or not notified at all, it would be a procedural violation, for which the law provides a recourse to the Commission, and powers to the Commission to penalize under Section 43A. So what is interconnected? What are steps to the transaction? I mean, it's a moving target all throughout. But what parties sort of tend to take the view that if if the transactions are taking place in the sense that they are steps to a particular transaction, they will be interconnected. They are required as part of the whole, rather the composite deal, they would be interconnected. Or if they are close enough in time, unless we can really make a point to say that those are actually two independent transactions going forward completely independently, and that really depends on facts to facts. But typically parties, and I think to some extent Amazon did so itself, when it came to the commercial transaction, it says, well, they're independent because of the proximity to time, I'm going to hold off on these transactions till I get your approval. So these are all moving targets, as jurisprudence of the CCI always is. It's fluid, as you said in your last talk.
Sure. Yeah, so I called it fluid jurisprudence because I don't understand for the life of me, Karan, that when the 2019 order records that there are certain intra-promoter transactions that are going to precede the Amazon's investment in FCPL, and there are constituent steps, you would think that, okay, the term, it's not being labeled as, it's not being labeled as interconnected transaction, but those constituent steps were part of the transaction at the time, and those sort of disclosures were made in terms of transaction documents, which makes me come to my follow-up question, Karan, to you. There is a Form 1 that has, certain details that, the parties have to disclose, and CCI has very well documented how those specific questions didn't elicit an honest answer from Amazon. But there were certain documents that were disclosed to CCI. The SHA was disclosed to the regulator. Can then today CCI come and say, hey, look, in the form, you didn't write the specific language that articulated your intent, and hence we are putting your transaction in abeyance? And does CCI have a positive obligation to read all the documents that you give to the regulator at the time that you're seeking the approval?
So as far what we constitute in the notice, Paswani, is not just what you write in the form, it's also the annexes and everything else that goes through. So there is an obligation of the CCI, and quite frankly, the CCI and all the parties that we have represented before combinations, the CCI does read material. It's not that it doesn't. And you get a lot of questions from the CCI, from the case team. Sometimes they come in the form of stopping the clock, and where you get follow-on notices. And this order also notes that a lot of questions were posed to Amazon to explain its position. Now, so the CCI does have an obligation to read. And in fact, the CCI doesn't stop there. CCI actually looks at other material outside of what the parties may have submitted. And that is why it's not that if the parties say the relevant market is X, the CCI is just going to fully accept it and say that this is, it was going to look at precedents in India and abroad, it's going to look at local conditions. Similarly, it's going to look at the documents to say, if I'm being told that that this is the rights I'm required, is that really true? Is there something else in the documents which have not come out? And so therefore, it is the duty of of the commission to look at the transaction holistically and not just confine itself to what the parties are submitting.
Sure. Karan, before I go to Sitesh and understand the implications of this in terms of, what's happening in Singapore, the arbitral proceedings, and here on what happens, let's say, in courts. As a competition lawyer who's regularly before the commission seeking deal approvals, is doing merger filings, how confused are you on what needs to be disclosed to the regulator, given that CCI has pointed to 2018 and 2019 internal email exchanges between the legal team of Amazon to the then CEO Jeff Bezos to then say that, hey, look, you articulated a different intent in your internal emails. And I mean, are you supposed to even give those internal emails to the CCI? At what point in the approval process does the CCI even get access to your emails? In terms of inclusions to, in your filings, how confused are you today?
Very, Ashwini. That's the short answer to your question, because I mean, what do we consider strategic? I mean, what is the definition? If I'm a PE fund and I'm a focused fund on a particular sector, then all my transactions are it's strategic for that focused fund to acquire more companies in that fund. So if I use to say that if I'm buying in retail and I'm buying another part of another company in retail, it's strategic for that fund because that's why my passive and my investors have invested on that basis that I'm going to be a focused fund. So it is going to be very difficult advising as to how far back one goes, and there will be a lot of times where I think we are going to now question our clients and question parties to say, is this the real true intent? And I think the most important takeaway from this order is that maybe especially when you're the acquirer, you take on the responsibility to do the filings all over the world. Now you would probably stop doing that and make it a joint obligation with the parties, because if tomorrow someone wants to, as we see in this case, if someone wants to go back and say this is not what the intention was, or there's been some suppression or misrepresentation, then both parties, both the buyer and seller, are on the hook.
Yeah. Because in this case, Amazon had sort of in his arguments mentioned that, look, whatever intra-promoter transactions happen, it's not my obligation to come and do those filings for you. If it triggered competition law, it's basically between FCPL and FRL to make those submissions, and not that those disclosures weren't made. But I'm not here to make Amazon's case in this conversation. So Sitesh, come in here that so it's safe to assume that this will be appealed by Amazon in the appellate tribunal. Help us understand on what happens from here on. Can Future Group and specifically Future Retail act as if Amazon doesn't exist and maybe go and try before the Supreme Court or Delhi High Court, and I don't know what's the right forum, to say that, look, now give me a go-ahead to sort of fructify my deal with Reliance, because this contract or this approval now is unlawful to that extent?
Yes, before I come to the implication of on the arbitration, I just wanted to make two quick points on some legal issues where the CCI may require a rethink. One is that the excitement of the business guys over a deal, over internal emails, can't really become the basis for saying that there was an intent to do more in the market. The thing is that after even analyzing all those emails, CCI comes to the conclusion that they were wanting to have a foot in the door. And I think the documents that were disclosed clearly would have shown even then that there was a possibility that there could be a foot in the door. So I don't think anything has changed as a result of these internal emails. And as I said, discussions between colleagues over a potential of a deal in a longer horizon and speculation about it cannot become the basis. What you have to examine is what are the real rights available at that point in time. And the real rights available were negative in nature, which allowed FCPL to have certain say in the way that the promoters could dispose of FRL's shares, etc. And that, those could convert later, that was a bargaining chip Amazon was hoping to convert into a bigger opportunity. But that was about it. I mean, there was no opportunity then. That's one. Second, I think reading the pleadings of arbitration and reading the pleadings of the filing as almost like a statute to say that you didn't say which and you didn't say where and word you didn't use this word or that word is, I think is not the correct way to go about it. Because when you make a filing in the CCI, you can give your own definition of the market, with the CCI may not agree. That's not misrepresentation. That's just a view of the facts. The facts were not misstated. The view of the facts was something which CCI is today saying was not correct. So therefore, and that's number one. And number two, when you make an arbitration claim, you try to give the full implications of a potential right that you have in legal terms. It is not the same as in market terms. So, as I said earlier, if the promoters were not wanting to sell FRL shares to Reliance, this question would not have arisen with regard to what Amazon could or not do without this. So therefore, I think comparing the pleadings and saying now you have said a different thing, as if reading the pleadings to be statutes, I think is not the right approach in an analysis.
Just for the benefit of our viewers here, to give them context, Sitesh, to what you're referring to, the CCI order makes references to certain, arguments that got made in the arbitral proceedings to make its case that, look, you said that you will do XYZ with these rights, or these are just protection rights. But before the arbitral tribunal, you were saying that, no, these rights means something completely else. Sitesh,
it gives us a greater control of FRL and all those things, but those are still in the stage of pleading. But coming to the question that you asked with regard to the implications on arbitration, I don't believe that the CCI's order to keep in abeyance affects the claim of Amazon so far as the contractual documents are concerned. That is because, as I said right in the beginning, the right doesn't get effaced. CCI's non-approval doesn't cancel the right. Even if the CCI doesn't approve a combination in a normal course, in any case, it can ask for a modification. The parties can suggest a modification. And the parties may provide that if the CCI approval is not forthcoming, there'll be a certain commercial arrangement that may come between them, which will have to be given effect to. So therefore, the fact that CCI is today questioning the transaction doesn't mean that Amazon has lost its right or lost its claim for violation of those rights. If you recall, we had similar issues in the put option, the assured return cases. And what was held is that if you have a contractual arrangement and ultimately that there is some way to give effect to it, then it has to be given effect to. In the present case, the rights that Amazon acquired have become valuable. If those rights cannot be implemented, the value may have to be given for it to Amazon by the arbitral tribunal. So
so you're
that's just assuming that CCI actually does not go through with the approval finally. But I'm saying that.
Yeah, but I'll come to that also in just a bit, given the FDI landscape and the restrictions, whether that Form 2 can actually be even filed by Amazon in its current shape and form. But just quickly going back, so you're saying the arbitral proceedings will continue as they are, and I mean, we hope. We understand that the arguments have culminated, and there are the order will probably come in January or something, but that order will need to be enforced in India, Sitesh. And this is a question that I sort of raised with Karan in the last conversation also. In light of this disapproval or abeyance order by CCI, does the enforcement become a challenge?
So the question of specific performance may come under a cloud if this order is to hold and CCI is to actually then deny the permission. But the damages case doesn't go away anywhere. So from a point of view of an arbitration claim, if the specific performance is not possible, the consequential damages that Amazon may suffer And there is a lot of role that the promoters has played in this process, and the FCPL has played in the process. So the arbitrators may be free to award damages to in favor of Amazon in lieu of the
which should not hit the enforcement hurdle to your mind on public policy grounds.
That's right. That's right. We have seen that play out in the RBI's objections to certain awards which came in for assured return put option matters and arbitration awards.
Sure.
To that.
Sure. Okay. So there is precedent on that damages might still need to be paid to Amazon. Sitesh, from a future group point of view, what is the strategy going to be here, given that CCI has passed this order, which again may get challenged, of course. But in terms of the deal between Future and Reliance, what role can this CCI order play?
So obviously, the strategy that that the Future Group will have is to use this order to say that Amazon's rights no longer exist. But as I just explained, that may not be the correct position, because Amazon's rights, FRL, still exist. Some of the negative rights may still be possible to be implemented. Even if Amazon cannot actually acquire or or enforce those rights, it can get damages. So therefore, if Future Group may have to assess what would be the potential damages that they may suffer on going ahead with this deal in violation of the agreement, notwithstanding the CCI order, and take a commercial call on it.
But Sitesh, I mean, we all know that Amazon's real interest is that the deal between Future Retail and Reliance shouldn't happen, given the dynamics of the retail market and the competitive advantage that Amazon wants to sort of play out here domestically. So I get your point on damages, but as to the deal itself, does Amazon now contend with just the money payout, which we all know is not the best situation or the best scenario outcome for Amazon? And Future Group and Reliance can today pretend that because the contract, which potentially could have mentioned even CCI approval, which Karan also mentioned last time in our conversation, could have been a condition precedent for that contract or the agreement to actually go through. What progress can Future and Reliance make on its deal?
So coming to the issue of condition precedent, once it is satisfied in a contract, it can't be unscrambled. So today, parties can't stand and say that actually the condition precedent was never satisfied. That they can only do if they can prove fraud. And this is nobody's case that there was any kind of fraud. So therefore, I think to use the CCI order to say condition precedent was not satisfied may not be possible. We are also assuming that the CCI order will hold till the end. Let's see how it plays out, because
no, of course. Look, I mean, given the yes, sort of zealousness of both parties, and rather all parties in this matter, who've not sort of waited for 24 hours, even in certain instances, to rush to courts. Future Group will try and capitalize this CCI order in some shape and form. I can only assume.
And of course, parties will do what they have to do in terms of legal strategy, and we are now not here to advise them on that. We can only assess the implications, or the larger implications of some of the things that come out of a high-profile, heavily litigated case like this on the legal landscape, the commercial landscape. And to that extent, I think allowing things like this to happen may have a chilling effect, as Karan, who's a regular practitioner, is saying. Difficult to say how we move from, in a matter, what else we need to say, and how much is enough and how much is not enough. You can always turn the clock back and say you didn't say enough, and these things like that make it difficult for parties to actually have a long-term commercial view and a short, a medium-term business plan. So therefore, so far as the deal is concerned, it may or may not go through. Ultimately, if the CCI decides that there is not going to be any approval for that document, then it will only play out in arbitration. I don't think there will be any possibility of the Amazon stopping the Reliance deal then. But still, I would say some time to go in that direction. And well, I mean, in a contract, ultimately, you either get specific performance or you get damages. So you cannot insist that, and specific performance is in many cases often a discretionary remedy dependent on the number of circumstances. So if one were to enter into a contract and have an apprehension that the other party is going to breach it, what you would typically look for is to get compensation by way of damages. If the strategic interest doesn't survive, then it's bad luck.
Sure. Sitesh, final question to you before I go to Karan for his quick thoughts on how does filing landscape change for other parties basis this order of the CCI. Can the Form 2 that the CCI has directed Amazon to make within the next 60 days, can it actually be made given that Amazon would want to keep, let's say, the form of the transaction or the substance of the transaction similar to what was in 2019, given the FDI policy restrictions?
So I don't think the Form 2, asking the parties to file the Form 2 is any kind of presumption of the nature of the deal one way or the other. The CCI now wants to examine that whether that foot in the door is actually the right to get inside the room. So therefore, it wants a more detailed filing of all aspects of the transaction. But it may still come to the same conclusion it did in 2019 after examining those details. And if Amazon can show that these are only negative rights and not really giving them the ability to control the business of apparel without some more things happening, which are totally unforeseen and may not actually happen, then say they can they can convince the CCI to approve the deal on the same facts. So the fact that they are asked to file a Form 2 is not presumption one way or the other that the deal will not be approved.
Okay, so Karan, I'll come to you. I don't even know how practical this is to form this file 2 at this stage, given that the parties involved are now at loggerheads. Final thoughts on the how do you see this likely to proceed, and do you want to articulate in a couple of sort of sentences the sort of confusion it throws up for merger control lawyers like yourself?
So I think maybe again, to Sitesh's point, we're not here to advise either party, but it seems that it's likely that this is going to go in appeal and get finally decided by the NCLAT to Supreme Court, and all parties seem to be love to litigate this all the way through. So we will soon know where we eventually land up. But I think the fundamental point, to me at least, remains is was there a competition assessment done at that stage? And I think the answer to that, at least to me, is yes, it was. So yes, maybe the CCI wants to have another look at it. Second, what it means for competition lawyers who are advising clients on merger control, well, it adds to the uncertainty. Your previous deals may become questionable. If you have a dispute, this is now opened up as another place where you can raise that dispute and try to raise these issues, especially if you want to litigate and fatigue parties with litigation. I think more importantly, the clients will now look to, when you're going through a merger control filing, you draft it for your party that you represent, and you always share it with the other side and get signed off from the other side, especially when you're talking about their business and the markets in which they operate. And there is this understanding that we're going into this together because we're trying to do this marriage together. And therefore, we get sign off from all parties, sometimes on a counsel-to-counsel basis, sometimes from the parties themselves. And I think that is going to change, because parties are going to question to say that if my today's counterparty, the one I'm going into the marriage with, tomorrow if there's a divorce, and they're going to go and question everything that I have said and the very basis on which they looked at, and then they said, go ahead, I think that is going to change, and parties are going to either ask for some sort of indemnity, some sort of there is going to be some legislative contractual drafting that would go and change this dynamic. And especially clients such as PEs, etc., are not going to like it, because they like to be in control of it. These are fast moving things. You need approvals. You're taking approvals not only in India but across the world. And one thing, you don't want one holdout jurisdiction. That is going to be the issue going forward.
And it's not just enough to protect yourself against the counterparty. As a litigator, I would say that I would be wary of business competition, and what mischief they can play even after 2 years after the deal is done. So really, we need to look at it more carefully, because this seems like a very serious turn that the CCI has taken with regard to what it expects from the parties, and what it can do with deals that have come before it, in terms of putting them at risk of unwinding them, and therefore and which is not aligned really to the business and the market expectations. So we need to look at this carefully, and whether this is something that will be business friendly in the long run.
And it's a final point, sorry, just to conclude, which is that I think having the association CIT in the door has actually put, to use the CCI's language, a foot in the door for third parties to be more vocal about deals going forward, and that is also something which is going to give parties some anxiety.
Sure. To your earlier description, Karan, I mean, get ready to draft watertight prenups. With that thought, thank you both, Karan and Sitesh, for joining me here to sort of dissect what the CCI order means for the merger control jurisprudence, and also the implications for Amazon, Future Group, and Reliance Retail, to the extent we could, given that there are a lot of moving parts to this whole equation now. Thank you both for joining me here this afternoon on BloombergQuint, and thank you so much for watching.
Thank you.